welcome back to the Anthony John Esquire podcast. I am AJ. Yesterday, before the argument in the Birthright Citizenship case, I did a primer for folks who wanted enough background to listen to the oral argument and know what the hell it was they were listening to. Today is the follow-up. The argument happened, I listened to it. This episode is about how it actually went, what mattered, which justices seemed skeptical of the Trump administration's position, where my own analysis held up, and where I'd probably tweak it a little bit. The short version is this. I think the government had a bad day. Not because every justice sounded hostile, and not because there were no serious questions for the other side, but because the justices who seemed to matter the most kept pressing the same basic problem. How do you get from a few narrow, historically accepted exceptions to birthright citizenship to a sweeping rule excluding the children of undocumented immigrants and temporary visitors? And the government never really answered that question. So that's what we're going to walk through. And first, let's be clear what this argument was about and what it was not about. It was not about whether the citizenship clause has any exceptions at all. Everyone agrees it does. Diplomats, enemy occupation, the old tribal Indian cases with their peculiar sovereign status problem. Nobody thinks the rule is literally without exception. The fight is over something much more specific, whether those narrow exceptions can be turned into a much broader rule that excludes children born here if their parents are here unlawfully, or even here lawfully, but only temporarily. So that was the battlefield, that stayed the battlefield, and the core phrases and cases were exactly the ones you'd expect. Subject to the lawful jurisdiction thereof, Elk versus Wiggins, Wong Kim Ark, domicile, allegiance, lawful presence. If you listened to the argument and felt like those words and phrases kept coming up over and over, yes, they did, because that's where the actual fight was happening. And one reason I felt pretty good listening to it is that a lot of the pressure points were really similar to the ones I flagged beforehand. Before the argument, I described the government's position as a kind of bait and switch and switch and switch. And what I meant was this. They start with a very few narrow and special case exceptions, the diplomats, invading armies, tribal Indians, and then try to leverage those into a much broader modern exclusion for a huge category of people. And Justice Roberts, albeit more judicially and less irritated than I, basically made the same point. He pressured the government on how these quirky, tiny, idiosyncratic exceptions became a rule for what he called a whole class of illegal aliens. So I'm a little bit proud that my objection was channeled by the chief. Another place where I think my earlier analysis tracked with the argument pretty closely was, surprisingly, Justice Thomas's opening question about the relationship between citizenship of the United States and citizenship of a state. In the podcast, I had pointed out that Wong Kim Ark itself says those are not the same thing. Residence matters for state citizenship. Birth, not residence, in the United States is what matters for national citizenship. Thomas more or less asked that exact question. The government dodged it, which is concerning, but I'm glad it came up. We also knew beforehand that the government's best move, and really maybe its only move, would be to cling hard to the fact that Wong Kim Ark's parents were domiciled and resident here and try to turn those facts into a constitutional requirement. That is, of course, exactly what happened. Say what you will about them, and I have a lot to say about them, they do have message discipline. The government tried to make domicile the linchpin, and multiple justices spent their time asking whether domicile was really part of the constitutional rule or just part of the facts of that particular case. So that forecast turned out to be accurate. Before looking at the justices individually, let me say that the advocates each performed really well. They both had impeccable command of the record. Sour is there often lately. This was, I think, only the second Supreme Court argument for the ACLU's Cecilia Wang, but both of them presented their arguments as well as those arguments could be presented. If they were running into any difficulties, it wasn't because of who was arguing, it was because of the position they had to try to hold. And that in turn tells us something more important than whether I called a few things right. It tells us which justices were actually doing the work that might decide the case. So let's start with Roberts, because I think that he was one of the clearest tells. Roberts began with skepticism, but I think he ended up sounding dismissive. He gave the government a fair chance to explain the move from a few narrow exceptions to a sweeping exclusion. He gave them the room to talk about birther tourism and modern realities, but after letting them do that, he basically cut the legs out from under the policy pitch. The key line to me is the title of this episode: New World, Same Constitution. That is a devastatingly simple way of saying, I don't care that you think the modern immigration context is different. You still have to persuade me that the Constitution means what you say it means. I did not hear Roberts sounding persuaded. Of course, because he's Roberts, he wasn't theatrical about it, but his position sounded clear to me. I've heard your theory, and I do not think your premises get you where you want to go. The justice who did maybe the sharpest damage, in my view, was Barrett. And what was so effective about it is that she didn't come in swinging rhetorically like Sotomayor or Kagan or Jackson. She just walked Sauer down the path of his own theory and let it fall apart. First, she gets him to concede that the children of slaves unlawfully brought here would still be citizens. That matters because those parents were brought here unlawfully, and obviously many of them would have wanted to leave if they could. So already the supposedly clean rule, lawful presence plus intent to remain, starts to smudge. And then Barrett springs the trap like it was inevitable. Okay, then what about people who have been illegally trafficked here today? That was a brutal move because it exposed that the government's rule is not really a rule in any stable sense. If unlawful arrival and lack of voluntary attachment do not defeat citizenship there, why are they supposed to do the work here? And when Sauer tried to answer that, the theory started sounding ad hoc and selective rather than principled. So I thought Barrett was excellent there, and I'm unashamed to say I will be renewing my membership to her fan club. Gorsuch was less flashy, but maybe just as damaging. His method was to take the government's theory seriously for the sake of argument, and then to keep asking what it would mean if you really believed it. Okay, are we using 1868 understandings of domicile or modern immigration law? If Congress can restrict lawful presence more and more over time, does that mean Congress can indirectly shrink constitutional citizenship? Whose domicile matters? The mother's? The father's? Both? Why is the constitutional text about the child if the rule actually turns on the parents? Remember that Wong Kim Ark said that Congress can expand citizenship, but not narrow it. I think, as we saw in the tariff case, Gorsuch is very concerned with the structure of government and the separation of powers, and here with the separation within powers as well, that Congress made this a constitutional amendment so that it could not simply be overwritten later by ordinary legislation. Sotomayor, of course, was one of the most direct critics of the government's position. She hammered Wong Kim Ark, the Secretary of State at the time, Daniel Webster's language, the narrow accepted exceptions, the historical debates. What she kept pressing was that the accepted exceptions are narrow for a reason. Diplomats are different. Occupied territory is different. Tribal status in the old cases was different. That does not mean ordinary non-citizens physically present in the U.S. are somehow outside U.S. jurisdiction in the relevant sense. She sounded to me fully unconvinced by the government's attempt to make allegiance and domicile do all this extra work. Kagan seemed less focused on emotionally resonant hypotheticals and more focused on conceptual coherence. Her basic point was, does the phrase subject to the jurisdiction thereof naturally mean what the government says it means? Or is the government smuggling in a technical, somewhat obscure allegiance plus domicile concept that the text itself does not naturally convey? And that's an important point because once you're reading a constitutional phrase in a way that feels strained, you need very strong history and very strong precedent to carry the burden. I don't think the government had either. Justice Jackson's most important contribution, I thought, was practical. She zeroed in on the problem that if lawful domicile depends on who Congress says can remain, then Congress winds up indirectly controlling constitutional citizenship. And that is awkward, to put it mildly, because the whole point of constitutionalizing citizenship in the 14th Amendment was to keep it from being too manipulable by ordinary politics. She also helped out Alito when the ACLU was resisting his account of why domicile made it into the Wong Kim Ark decision. She made what I thought was a genuinely important law in action point, that the domicile discussion there may not have been included because it was binding to the result, but because the court understood that the public was going to be resistant to the decision. And so the Chinese parents in that case were being framed as sympathetically as possible, even though that framing was not essential to the outcome. I thought that that was one of the best observations in the whole argument. On a purely personal note, I found it a little annoying that she kept interjecting and interrupting, and especially when she almost didn't let Barrett finish her lethal trafficking question. But that, of course, is separate from the substance. And on the substance of her point, I thought it was very real and important. So Thomas is still harder for me to read from tone alone. His questions were surprisingly foundational. He opened with Dred Scott and state versus national citizenship. Opening with Dred Scott gave the government an opportunity to frame the citizenship clause around its original purpose, but the state versus national citizenship issue was so clearly addressed in Wong Kim Ark that even asking it could be seen as putting pressure on the government. So that was surprising and interesting. Alito, by contrast, seemed the most sympathetic to the government. He was the one most willing to entertain the idea that a general constitutional principle could extend to modern phenomena like unlawful immigration, even if the exact circumstance was not central in 1868. Kavanaugh was narrower and mostly quiet when he did talk. His focus was on Congress's later reuse of the same citizenship language and whether it mattered because it cut against the idea that this language had some hidden narrow meaning all along. So, in sum, that's how the justices sounded to me. But let me be fair to the government for a minute, because I do think they had a theory. I just don't think it held together. As we discussed in the last podcast, the government's best argument is that the subject to the jurisdiction thereof means something more than merely being present and subject to ordinary law enforcement. It means something more like full political jurisdiction, complete allegiance, and for non-citizens, that the allegiance is tied to lawful domicile. That was the best version of their position. The problem is that once the justices started asking how the theory actually works, it kept falling apart. First, Roberts asked how narrow exceptions became a sweeping category rule. Second, multiple justices asked whether domicile in Wong Kim Ark was actually part of the constitutional holding or just part of the factual setup. Third, Barrett exposed the theory does not handle slavery and trafficking examples in any consistent way. Fourth, Jackson and Gorsuch showed that if the theory depends on lawful domicile, as defined by Congress, Congress might wind up being able to manipulate constitutional citizenship indirectly. So the issue wasn't that the government lacked words. It was that when those words were tested, they stopped looking stable and started looking like an argument built to get a preferred result. And when that happens at oral argument, that usually matters. I do think there's a significant note I'd make regarding what I thought mattered in the pre-argument episode. Before the argument, I'd hoped that the executive authority point, that the president doesn't get to define citizenship by executive order and that Congress controls naturalization, I hope that that might matter more during the argument than it actually ended up mattering. It's still true, and I think it's important, but at argument, the real fight was even more squarely about the meaning of the citizenship clause than about presidential power in the abstract. So, if I were redoing the primer from scratch, I would still mention the executive power bit, but I would spend even more of my time on Wong Kim Ark, ELK, jurisdiction, allegiance, domicile, narrow exceptions, etc. And all that leads us to the obvious question: how will they vote? I had originally said that I thought it would be in keeping with how they voted in the tariff case, and right now that remains my best guess. 6-3 against the government. I think that Roberts, Sotomayor, Kagan, Jackson, Gorsuch, and Barrett are the likeliest votes against Trump's position. I think that Alito and Thomas are the likeliest dissenters, since they were the dissenters in both the tariff case and the National Guard case. And I think they'll probably be joined by Kavanaugh, who wrote the lead dissent in the tariff case. Could it be 9-0? It should be. Could it be 7-2? Also, sure. This is the modern Supreme Court, and prediction is always uncertain at best. But if I had to call today, I'd say the government had a bad argument day and probably loses. And I say that not because I want them to lose. I mean, I do. But because if you listen to the argument, the side that kept having to explain itself, retreat, reformulate, and explain itself again was the government. So my takeaway is pretty simple. The government came into this argument needing to show that a few narrow, historically accepted exceptions to birthright citizenship can be expanded into a sweeping modern rule. I don't think they did that. The more the justices pressed for the bridge between those narrow exceptions and the rule the government wants, the more rickety that bridge looked. That does not guarantee the outcome. Nothing ever does. But if you were listening for who sounded like they had the cleaner theory, the more stable limiting principle, the better fit with Wong Kim Ark, I do not think the government won that contest. Anyway, that's where I think things stand after argument. When the decision comes down, we'll be back and talk about what the court actually did. Thanks for joining me.